Hi everyone, welcome to the webinar. Thank you for joining us for Tenants' Rights Tuesdays. This is session number 2. And if you missed the first one, it will be posted on the YouTube page, so I'll put that link in the chat. I should have that done this week. My name is Christy Baglow. I'm the Director of Statewide Training at Florida Legal Services. I'm so glad you could join us today. And before I introduce our wonderful speakers, I just have a few announcements to get through. This webinar is being recorded, and I will email the recording out to everyone by tomorrow, so you'll all have that to share with anyone who couldn't join us today. I also wanted to remind everyone that there's one more session of Tenants' Rights Tuesdays, and it will be next Tuesday, September 15th, also at 2 o'clock. So I'll put the link to that in the chat box also. And I think I told you I'll put the link to the YouTube page in the chat box also. And we will hold questions for the end just to make sure we can get through all the material in the allotted time. So you can type in your questions. There should be a Q&A box on your screen. If you're joining from your phone, you may have to go down to the bottom of your screen and kind of wake up the toolbar at the bottom, and you should see the Q&A box. We'll also be having a few interactive polls, so you also may need to wake up your little toolbar if you're joining by your phone. That way you can participate in the polls. So I am so happy to have with us again today, Dr. Andrea Mosley. She's down there at the bottom of the screen. She's the Managing Attorney of Fair Housing Programs at Community Legal Services in Mid-Florida. And we also have Suzanne Garrow, who is the coordinator of Eviction Defense Self-Help Project and a staff attorney at Jacksonville Area Legal Aid. So I'm so glad they're back with us again today to share their wealth of information with you. Welcome everyone, and we will go ahead and begin.
Hello everybody, thanks for joining us today. We have a lot of information to get through, so we are going to try and move through these slides and leave you some time for questions at the end. So if we can move to the first slide. So the very first thing you need to think about when these issues present themselves to you as tenants are what law applies. And so there is a Chapter 83, a section that applies to residential tenancies. That means if you live in an apartment, if you live in a house, if you live in a house that has multiple rooms and you share a common space, if you live in a duplex, that's all Chapter 83. There is also Chapter 723 that applies when a tenant owns a mobile home but rents the lot from the mobile home park. So that's a different set of laws with different sets of protections. Some of the general residential tenancy laws apply under certain circumstances, but 723 is the governing law there. Next slide, please. So residential tenancies, I started to list off what they are. It's when tenants pay rent but do not own the property. It could also be, there are some people who come to us with rent to own provisions and have rent to own situations, and certain things might apply there. So if you have that sort of situation, you should contact your local legal aid and find out if that applies. Next slide, please. So there are different types of rental agreements. You can have an oral agreement or you can have a written agreement. An oral agreement is basically a non-written rental agreement. So you agree to rent a place from a landlord or manager. They agree to provide you a place to live, and you typically agree to pay rent, and then there are other duties and benefits that we'll discuss as we go on. The downfalls to oral agreements are there could be misunderstandings because it's just a discussion. Also issues can exist about proving what you agreed to because it's not in writing. The benefits of an oral agreement, particularly if it's for a limited term like month to month, is flexibility of those agreements. There can also be written leases, and I will tell you in Florida, most agreements to rent are written leases, and the benefits of that is it gives tenants and landlords the clear rights and responsibilities that they have. And if you have a written lease agreement that you've signed with your landlord or with the property manager, make sure you get a copy and keep a copy for yourselves. Next slide, please. Actually, can we flip back quickly, since there is a little. In addition, if you want to change your written rental agreement with your landlord, any changes, and all changes should be in writing, signed by both parties. The downfalls is sort of the opposite of the flexibility. You must be released from the lease to move without penalty. You have a certain term, and you are liable for that term, typically speaking. Next slide, please. So just to give you a little more information about written lease agreements, they contain terms of the tenancy. They should name all the tenants. That's important. As I just mentioned, it limits the time on the occupancy. It will state the monthly rental amount and any additional terms. It should state the security deposit if there is one and any additional terms. Sometimes there are varying responsibilities on who does the repair, so it will set forth those responsibilities if they're not otherwise set by statute. It'll set forth any restrictions that there are to the tenancy. It may set forth access to the property by the landlord. It may have other disclosures that are required by law relating to any particular things that exist, any conditions that exist that are required to be disclosed. It should be signed by the landlord and the tenant. And the considerations at that time, you may think of if you need accommodations of some sort, you may think of it at that time, and reasonable accommodation for any sort of disability, like wanting to or needing an emotional support animal, as a for instance, you may want to put it right in the lease so there's no confusion. Next slide, please.
Okay, so mobile home park leases. So
looks like Andrea may be kicked off for the moment, so I'll just go through this briefly. There is no rental agreement shall be offered by a park owner for a term less than 1 year. And if there is no written rental agreement, no rental term shall be less than 1 year from the date of the initial occupancy. However, the initial term may be less than 1 year in order to permit the park owner to have all rental agreements within the park commence at the same time. Thereafter, all terms shall be for a minimum of 1 year. The thought there is that it is a big endeavor when you own a home and rent it in a park to otherwise move from that. If a notice of increase in lot rental amount is not given 90 days before the renewal date of the rental agreement must remain under the same terms until a 90-day notice of increase in lot rental amount is given. The notice may provide for a rental term shorter than 1 year in order to maintain the same renewal date. A mobile home lot rental agreement may provide a specific duration with regard to the amount of rental payments and other conditions of the tenancy, but the agreement shall neither provide for nor be construed to provide for the termination of any tenancy except as provided for within the statute. So there are more limitations, again, because you own the home, but rent the lot. Any provision in the rental agreement is void and unenforceable to the extent that it attempts to waive or preclude the rights, remedies, or requirements set forth in this chapter or arising under laws. Next slide, please. So I spoke a little bit about reasonable accommodations at the time of your lease. Is a good time to anticipate those you might need if you are a person with a disability who might be requesting a reasonable accommodation as a part of their tenancy, so you can have full use and enjoyment of the dwelling. So it's a request for an exception or adjustment to the rules, policies, practices, and services of a housing provider so that you can have equal opportunity and use of a dwelling. So there may be a no pet policy, no dogs, but you might need an emotional support animal. That is not a pet, that is a reasonable accommodation needed to mitigate the symptoms of your disability. If there is no assigned parking space, you might ask for an assigned parking space or for a disabled parking space or both. If you're a person with a disability with some sort of limitations in your impairment, you can do that at any time in your tenancy, but certainly when you're commencing the tenancy at the beginning, it's great if you can anticipate it and put it in the lease. Next slide, please. So what sort of reasonable accommodations might exist, or why might they be needed? Sometimes there are noise complaints, unauthorized occupants, violation of the no pet policy. These are multiple police visits, failure to maintain the property, dirty houses, parking space, smoking violations. These are all possible violations that can be addressed, that can be relieved if somebody is a person with a disability and certain reasonable accommodations are made. So for instance, the failure to maintain a property can be a problem. However, if you are a person with a mental health disability that does not allow you to fully maintain your property, you can get assistance and be relieved of some of the duties yourself by not from the, you may be able to get somebody in an agency or somebody like that to assist you in maintaining, similarly with keeping your house clean. Those are all requirements. Next slide, and I think we have Dr. Mosley back.
Sorry, Suzanne. I don't know what happened, but
I think just people are getting tired of hearing me speak, so I'm glad you're back. Welcome.
it wouldn't be one of our presentations if something didn't happen, right? So emotional support animals, or ESAs. Emotional support animals provide emotional support, comfort, well-being that alleviates one or more identified effects of a person's disability. The housing provider can ask for documentation of the disability-related need for emotional support animal from a healthcare professional. It has to be animals that are commonly kept in households, like dogs, cats, small birds, that type of thing. If not, your letter has to say why you have a disability-related need for this animal. For instance, a snake or a chicken. A Senate Bill 1084 says that if you have more than, it says a lot of things, but basically, if you have more than one emotional support animal, so you need 2 cats or 2 dogs, the provider needs to give a disability-related need for each animal, and it makes it criminal for the housing provider, the healthcare provider, to give information that they don't have any knowledge of. So it makes it a little bit harder for you to get a healthcare provider to state that you need an emotional support animal. But I use this cartoon a lot because it's basically, it sums up what an emotional support animal is. It's to give you emotional support, you know. It builds on the animal's natural tendency to know when something's wrong. And then they give you emotional support, which alleviates a symptom of your disability. Next page. So we have a poll here, and we have a question. Does a landlord have a duty to provide working air conditioning? So when you're renting, does your landlord have to provide you working air conditioning? Like in the middle of August when it's super hot, sitting in your car at 6 p.m. is 101 outside. Does your landlord have to give you air conditioning in your house?
Okay, we got about half of people voting. Don't be too shy, everyone else.
Yes.
I was making this poll. I almost added an option. Yes, air conditioning is a human right in Florida. Felt like it should be. Okay, so we've got the majority of people voting, so I'm going to go ahead and close the poll. 23% said yes, it's required, and 77% said no, it's not required.
Yes, you are super smart, our gang. No, it is not required. You live in Florida and air conditioning is not required. But guess what is? Heat. Yeah.
Yeah. A landlord can accept the duty in a lease. There's a decent argument that if a landlord had a working air conditioner when you moved in, it should remain working, but it is not required under Florida law.
Yes. Yes. All right. I'm still seeing the poll, so I'm going to close mine out. All right. Would you like me to do a couple, Suzanne, or?
Yes, why don't you?
All right. I guess I should do my part, huh? All right, landlord duties. Okay, so for all tenancies, the landlord has to maintain the roof, hurricane season, windows, screens, doors, floors, steps, porches, exterior walls, foundation, all structural components in good repair. Plumbing must be in reasonable working order. You have a right to quiet use and enjoyment of your apartment. That means that it's the landlord's duty to ensure that you can use your apartment and enjoy it and not be disturbed by a lot of loud, disruptive behavior from your neighbors. Non-discrimination on the basis of race, color, national origin, religion, sex, familial status, and disability if your landlord is covered by the Fair Housing Act. For apartment complexes, they have to do extermination. That's rodents, mice, wood destroying organisms, and bed bugs. Termites is the word, right? Locks and keys. So they maintain the locks. They are to provide you keys. Clean and safe condition of the common areas. Garbage disposal facilities, outside receptacles, and functioning facilities for running water, hot water, and heat during the winter. But no AC in the summer. Okay, mobile homes. So as we discussed, 723 covers if you own the mobile home and you're renting the lot. The owner's general obligations are to comply with the requirements of applicable, I always trip up on that word, building, housing, and health codes. Maintain buildings and improvements in common areas and good and safe repair and maintenance. Keep up the appearance of the mobile home park, safety and cleanliness, provide access to common areas, including buildings, and improvements there too, and at all reasonable times for the benefit of the residents and your guests. Maintain utility connections and systems for the park owner is responsible for the proper operating condition of those utilities. Comply with properly promulgated park rules. This happens a lot. So a lot of people don't know the park rules. You are entitled to the park rules and you should know your park rules because that's really what you're going to be held to. Along with the statute, really you're held to the park rules. How long can a guest stay? Those type of things. How many pets can you have? What size pets? All those things are in your park rules, and you should always have a copy, even if you buy your mobile home from someone else. Often you're buying your mobile home from the last person who owned it and not really the park, but you still should get the mobile home park rules because that's what that's how you know what you're being held to. Your obligations are to comply with all the obligations imposed on a mobile home owner, including health, safety. You are responsible for the upkeep of your own mobile home because it's yours. You are responsible for the lot to keep it clean, neat, and sanitary. Sometimes people have septic systems and things under their lot, and you are responsible for that. Comply with the properly promulgated park rules and regulations and require other persons on the premises to do so. So you are responsible for yourself and the conduct of your guests. So that's something to be careful of. Next slide. All right, Suzanne, you're on.
So we addressed a little bit the requirement of the landlord not to discriminate on the basis of protected classes when they're renting to you, when they're providing services to you. And this is just a note here that there is a new class protected, maybe under the Federal Fair Housing Act, and that's actually both sexual orientation as well as gender identity. Very recently, in June 2020, a new case came out. It was issued by the Supreme Court in the employment context, Title VII, saying that Title VII, which protects people from discrimination in employment, also covers sexual orientation and gender identity, although not listed in the statute. And that has been used, that being Title VII, has been used often to interpret the Federal Fair Housing Act. So there is quite potentially, we believe, the protections available for trans people as well as sexual orientation under the Federal Fair Housing Act now. So if you have an issue, you can file a complaint with HUD. You can call your local fair housing organization, but know that this could be a change that is a welcome change and a growth or a further interpretation of the Federal Fair Housing Act. Next slide, please.
All right, so what are your tenant duties under Chapter 83? Well, you have to comply with the obligations imposed by building, housing, and health codes. You have to keep the premises that you occupy clean and sanitary. You need to remove all garbage. You need to keep plumbing fixtures and working order, so you can't flush things down the toilet that would destroy the plumbing. even though plumbing is the landlord's responsibility. You have to operate the electrical, plumbing, sanitary, heating, ventilating, air conditioning in reasonable manner. And there are a lot of leases that require that you change the, what do you call them, filters on air conditioning. So if that is in your lease, that is your responsibility. You don't destroy, deface, damage, or impair or remove any part of the premises or property. Conduct yourself and require your guests to conduct themselves in a way that does not disturb your neighbors or constitute a breach of peace. That goes along with quiet use and enjoyment. That is the duty that you owe your fellow tenants and neighbors, and any issues regarding hoarding. So if you have a lot of property within the building or that spills without, that is an issue that you need to correct. Next page.
Next is landlord access to the premises. So there are times when you must give access to the premises. In the case of an emergency, they may have immediate access. Pursuant to a court order, you have to grant access to your landlord. Obviously, if you consent, your landlord can have access to the premises. You must not withhold access if your landlord is trying to show the property. You're not allowed to unreasonably withhold consent. When a tenant is absent from the premises for a period of time equal to 1/2 time of the periodic rental payments, typically a month, so for a couple of weeks. If the rent is current and the tenant notifies the landlord of an intended absence, then the landlord may only enter with the consent of the tenant or for the protection or preservation of the premises. So if you let them know you're gone, they can't come in, but they may be able to come in under other circumstances. Now, absent an emergency, the landlord may enter the rental unit on reasonable notice to the tenant to make reasonable repairs at a reasonable time. Reasonable notice has been defined in the law as 12 hours prior to entry. So it's a pretty short window that you're supposed to give access. And reasonable time has been between the hours of 7:30 a.m. and 8 p.m. We've had a bunch of people call lately asking about giving access to their landlord during this COVID emergency. Can the landlord go in? The answer is yes, maybe, under most circumstances. If the tenant has some sort of physical condition or condition that is somehow worsened by COVID, then there are going to have to be some agreements made. There may be a reasonable accommodation there, but typically, there could be masks, there can be some sort of isolation, but typically you do have to give your landlord the right to enter. So any condition, non-COVID related, may have to be reasonably accommodated. So you just need to let your landlord know and have a reason to have some sort of delayed access. But the right of entry by the landlord should not be abused or used in any way to harass the tenant. It is to do repairs or show or whatever the specifics are as needed.
But Suzanne, can your lease say that the landlord's access is different other than what is in the statute?
Yes, your lease can say it is different than other than what is in the statute. If it gives a smaller amount of time, I would say that may not be an enforceable provision of the lease, but generally speaking, if both parties agree to it, you're going to have to let the landlord enter as defined in the lease.
And we have had a lot of issues with COVID lately in Central Florida. So if there is a disability related need, to limit the landlord's access, or to ask that the landlord and any assistants or service providers wear PPE, that type of thing. We have done that. So if there's a disability related need, you can do that. But otherwise, as Suzanne says, you're required.
Next slide, please.
All right, withholding rent for maintenance and repairs. The repair must be something that the landlord is obligated to take care of. That's your first evaluation. Am I responsible, or is the landlord responsible? Because you can't withhold rent if you're responsible. The tenant must provide the landlord with written notice with the opportunity to fix the problem. So you can't just say this is not working, so I'm not paying my rent when your rent's due on the same day, right? And so the tenant must hold the rent in a safe place. After repairs, the rent is still due. So for this, I always tell my clients, you have two options. You can withhold rent, and if it is not fixed, you can use the money you are withholding to fix it. Or you can say, I'm going to vacate the property. But you can't withhold rent and just stay.
I will say though, that if you're going to fix the condition, you need to tell the landlord and get the agreement from that landlord in writing to be able to repair and deduct it from your rent.
Yes, yes. It always depends on what it is. So, I would say if you're in doubt, call. We're here, Suzanne's here. You have to call to get advice. Should I get this in writing, or is this an emergency situation and he's not fixing it? Can I fix it, or should I leave, right? And so if you do this and then pay rent, guess what? You waived it and you got to keep paying rent, and you have to send another one. So be aware of that. Did I miss anything? Next slide.
So the specifics of withholding rent and the notice needs to be there are very specific statutory requirements to telling your landlord that you're going to withhold rent. So as Andrea mentioned, you have to provide the landlord with written notice and give them 7 days to repair the problem before you can start withholding rent. You have to specify the non-compliance. You have to tell them what's wrong and indicate your intention to withhold rent if they don't fix within 7 days until the problem is fixed. You should provide that notice to the landlord in some way that will evidence receipt. I will tell you, I tell a lot of my clients, if you have a text, you should text it to the person in charge. You can put it in the mail too, but a text is great because it starts the clock running. Same with email. But you want to be able to prove that it was received. One warning is certified mail is not the best option because it can be refused. First class mail is usually better because if it's not returned, it's presumed received. Also, notice should contain the intent to terminate tenancy if desired. So what I advise people to do is to do a notice that says they intend to withhold their rent and or terminate their tenancy, because you have to tell the landlord those are your intentions and give them 7 days for you to be able to do those things.
Yes. First class mail, you can track it. And if you just do certified mail, not return receipt, you can see that it was delivered, and they don't have to sign for it. The return receipt is what they have to sign. So I say, if you're going to send a certified, but don't do return receipt. Don't use the green card. And you can see online that it was delivered, and that is proof. They don't have to sign for it. They don't have to do anything. And as Suzanne said, if it doesn't come back, they received it. We are having issues with the post office though, so.
Text it to them if you can. Email.
What about email?
Email's great. It shows that it was delivered. It shows, and if you want to put it in the mail too, that's fine. But I think anything that is quick and shows that it was not returned, evidence is receipt. Plus, you'll say that you sent it.
Especially if you guys are texting each other the entire tenancy, that's how you communicate. And
Definitely.
keep up with the texting, but preserve the text messages. Some people lose their text messages when they switch phones, whatever the case may be. You need to preserve those text messages.
Absolutely.
Use an app, screenshot, email it to yourself, preserve those text messages.
Next slide, please.
What happens if the landlord fails to repair? Well, just as we have been discussing, you can withhold the rent pursuant to a 7-day notice, or you can terminate the lease agreement so long as the 7-day notice preserve that right. So exactly what Suzanne said, you have to let them know in the 7-day notice that you are either going to withhold or terminate. There are certain circumstances that would be better for one or the other, right? So if you just want them to fix something, then 7 days. If it's a threat to your health or safety and you can give them that much notice, I'm going to terminate if you don't fix it. That type of thing. That's how I kind of base the difference, right? You can also at any time call code enforcement, but just so you know, code enforcement does not deal with mold, at least here. In Central Florida, they do not deal with mold. They're not gonna tell you got a mold problem, but you can still call them at any time. And a failure to repair can also be the basis for a reasonable accommodation request depending on what the repair is. So if they're not fixing the electricity and you need a machine that's powered by electricity, that's a reasonable accommodation request. So all those things can come into play. You just need to be aware that you do have rights, but you also have responsibilities. So that's the purpose of that slide. Next slide.
Let me just say one quick thing about code enforcement. Here, mold is not covered, not a condition. But one tip is to try to identify, you're not going to know exactly necessarily, but the source of the moisture, because the thing that is causing the moisture, the leaky roof, the not window or not weather-tight windows, not weather-tight doors, those are conditions that can be cited. So putting the mold aside, but the source of the moisture may be a condition.
And if you have persistent mold, call an attorney first, because many times once you've given them a chance to fix it and the mold comes back, then you have a bigger problem. And if they're just going to spray bleach on it and no one's going to be able to determine how bad your mold problem is. So if you have persistent mold problem, call the attorney after you give them an opportunity to fix it. Retaliation. A landlord may not retaliate against a tenant for exercising their rights under local, state, or federal law. So you send a 7-day notice for repairs. You call code enforcement. You make a reasonable accommodation request or file a fair housing complaint. Pursuant to the statute listed, 8364, that is retaliation and that is unlawful. So retaliation can be not refusing to do any other repairs, or I often tell my clients what you will receive in response to a 7-day notice is an eviction notice. So that's retaliation and it happens and it's unlawful. Next slide. Ooh. Oh, I like that picture too. We have a poll. Due to COVID, many times court hearings are via video or some other platform. Do you have the technology necessary to attend a virtual hearing. And those are your choices. I have a smartphone, A, I have a home computer, B, or C, I only have a regular phone, D, I do not have a smartphone or a computer.
All right, I got the poll launched so everyone can go ahead and vote. All right, you guys are on top of this right now. We already got over half of the people voting. I'll give everyone 5 more seconds. 5, 4, 3, 2, 1. Okay, so it looks like 42% said A, yes, they have all necessary technology. 55% said B. C, only one person, and no one for D, so that's good news.
That's excellent. I would hope if you are watching this, you have the technology to attend a court hearing. Yeah, it's important. I've gotten a couple of hearings where the notice was only a Zoom link, not even a phone number, so.
And some judges require you to join by video, right?
They only give you a Zoom link, not even a phone number. So something to be aware of. All right. And I'm gonna close that one.
All right, and the reason why we ask you about your Zoom technology and your smartphone technology is because there are still evictions going on out there, and we're not going to talk about them this week. That's going to be our primary focus for next week, but we do want to mention several things, several protections out there that you should be aware of during this time, during COVID in particular, but just in general. Let's start with the Federal CARES Act. The Federal CARES Act gives eviction protections for tenants facing eviction due to COVID. And so what that means is people who are experiencing a loss of income due to COVID, that experience a loss of income between the time that federal law was enacted, March 27th till July 25th, it still requires, even though the law is no longer active, it still requires, the portion that requires a 30-day notice to pay your rent is still active. And so this is limited in that it is only applicable in HUD-funded or tax credit properties, so in subsidized properties, or to landlords who have what's called a federally backed mortgage. They have a Fannie Mae or a Freddie Mac mortgage. They have the VA mortgage, an FHA mortgage. And those links that are up there are links you can use to try to determine whether your landlord has a federally backed mortgage. So if you're in a private landlord-tenant situation, not subsidized housing, and want to know if they have a federally backed mortgage, or if you're not sure if your landlord gets tax credits, you're in a big complex, you can check these websites to see if they are Fannie Mae or Freddie Mac. And you just may not know, and we'll talk a little bit about that before in a moment. So you may have CARES Act protection. It means that they have to send you a 30-day notice to pay your rent. It doesn't eliminate or waive the rent, but your landlord has to wait those 30 days to file and give you the opportunity to pay. They also, under the CARES Act. There's also, as of September 4th, so just a few days ago, the Centers for Disease Control moratorium. And that is for people experiencing a loss of income, not any loss of income, not necessarily COVID related, who cannot pay their rent at this time. And so that will, for non-payment of rent cases that are filed, you may have this Center for Disease Control moratorium coverage. There are certain requirements. There are about 5 different requirements that you have to meet in order to be eligible for this particular defense. You also have to sign a declaration under pains and penalties of perjury. You don't have to have it notarized. It's a declaration, but you have to sign something that says you're qualified. And again, I will tell you where you find that in just a moment, but if you're qualified, you can provide the, you can provide your landlord this notice and then raise this defense. There's also the governor's moratorium, which is now very limited, and it was much more broad, but it has been narrowed significantly. But the governor's moratorium is supposed to prevent in non-payment of rent cases that are due to a loss due to COVID, the final action for eviction. So that's suspended right now until October 1st under the governor's moratorium. Again, this does not eliminate or waive rent. You still have to pay it to avoid future eviction, but it can temporarily suspend the eviction. Lastly, you need to just check your county. There's a website there to check your county because there are special or different protections in different counties that may apply. So those are kind of the overall things that could apply.
And I have a couple questions before you get to the fantastic website.
Okay, all right.
Can a landlord, the landlord is not prevented from filing an eviction under any of these protections, correct?
That's absolutely right. A landlord can file an eviction case. These are defenses to the eviction, so they have to be raised by the tenant. Otherwise,
Okay.
To the court. Otherwise, the court will never know about them because the landlord does have the right to file the eviction case. Mm-hmm. They also have to raise them in the context of something called a motion to determine rent, because under Florida law, a tenant in a non-payment of rent case must deposit the undisputed rent into the registry. So if you want to dispute that amount of rent, or that the rent is due under any of these moratorium, you have to file a motion for to determine what rent is due, hoping it's zero until the end of those moratorium, until those expire.
So you file your answer, and part of your answer is the whatever moratorium applies to you. And exactly. Then you also do the motion to determine rent, which is also whatever moratorium applies to you. Exactly,
and multiple could apply to, they're all non-payment of rent cases, and all but the CDC moratorium has to be COVID-related loss of income.
And in the end, it looks like it's the governor's moratorium, which is for a month, right? That prevents the execution of a writ, right?
I think all of them would at this particular time. I mean, if you're covered by those defenses, you should have more protections under the others, I think.
Yes. And so, how do we write our defense? What do we do?
So what you do is go to www.floridaevictionhelp.org. We at JALA have, with assistance and grants, we have developed an eviction form builder website. So if you go to floridahelp.org, there is an interactive website, interactive questionnaire that you fill out. You have your complaint in front of you, and it will ask you questions to walk you through these various defenses. And then at the end, it creates an answer form and a motion to determine rent that will set forth these defenses. So you file your answer with the court at that time, based on what's printed from the form builder. So it'll literally just walk you through all the COVID-related defenses. One thing to note, when I was talking about the CARES Act, if you don't know, there is a provision for that in the form builder. If you just don't know and can't determine whether your landlord has a federally backed mortgage because you can't find it anywhere, you ask the court to have the landlord declare that they do not have a federally backed mortgage, show proof that they are otherwise entitled to move forward on a notice less than a 30-day notice. So all of these are anticipated, all these defenses are anticipated within the form builder.
You're not lost because your landlord's not going to volunteer that information.
That's right, that's right. But you ask the court to inquire at the hearing. So the form builder will take you through all of that and puts together the answer that you can then file.
So do you have to have a way to print the answer, or what happens at the end?
You do. You have to find a way to print the answer. So if you don't have printing capabilities, you can people often go to UPS stores, if their local libraries or other are open, which many are, I think, these days. They can go print at libraries, but you do have to have a way to print it, and then to also, you have to get it to the court where the eviction is pending, because the court has to know that you have these defenses in order to get your defenses and to raise them.
Mm-hmm. Awesome.
So other than that, I guess I will say just one more thing about the motion to determine rent. I mentioned that the law typically says that in a non-payment of rent case, you have to deposit all the rent that's undisputed into the court. Here, we hope that if you raise these defenses saying that the payment should be suspended in total, that's the governor's moratorium, or the CDC has coverage to otherwise toll some of these evictions, that you won't be required to put all of that rent in. But again, you need to go to our website. I know for sure jackslegalaid.org has description of all the requirements for all these different moratoriums. So you should look at them carefully, because you need to follow what is required. You have to give your declaration to the landlord before you file your answer. So there's an order for all these things that is particular. So.
Wonderful. Thank you, Suzanne, for all your work on creating the eviction defense form builder, you and your team at Jacksonville Area Legal Aid. I just wanted to let everyone know that once I end the webinar, Zoom will take you directly to that website so you can check out the form builder.
Nice.
Excellent. Thank you.
Awesome.
I think we've got questions next. Questions. So we had a couple questions come in. So the first one, all right, heebie-jeebie warning to everyone. For subsidized housing units, can the landlord pass on treatment for bed bugs? Can the landlord pass the cost of the treatment for bed bugs on to tenants?
I believe so.
Let me dig in my brain, but I'm thinking I can.
I mean, if it's something that is tenant caused, I believe so. Although I have to say,
That's usually what they say. They say that the tenant caused the bed bugs, and therefore they have to pay for the cost of removing the bed bugs. Typically, that's the situation. But if it's not addressed anywhere in your lease, you can call a legal aid, and they'll discuss it with you. But that's often a cost that you will bear. Based on the fact that bed bugs typically, they will say came with you.
And I mean, I think you can dispute it if you can show that otherwise happened.
If everyone in the building has it, and they had it, they were dealing with it before you moved in, then of course probably that's not you. But you will have to go. That's one of those things where you need to address with the attorney, because bed bugs is contentious.
All right, there's a follow-up question to that. What if the methods tried to treat the bed bugs are not successful? Are they required? I'm not sure if the questionnaire is talking about the landlord or the tenant, but either one. Is anyone required to try alternative type treatments like chemical treatments, heat treatments until they're gone?
Yeah, I mean, typically remediation of a problem is until the problem is addressed. So I don't think that's any different with any type of condition. It may be more intractable. Bed bugs has a very specific heat treatment that's needed, and they have to use effective remediation. I don't think it's any different with any condition. So the answer is remediation needs to be effective regardless.
Mm-hmm.
Okay. And if a 7-day notice for the water not running is given and landlord does not repair and tenant wants to stay because it's hard to find a new place, would the lawsuit be likely to force the landlord to repair?
So it's not a lawsuit, it's a 7-day notice that gives notice of an intent to withhold rent. That's the thought, is if you have a decent landlord and you say there's something wrong and they haven't been answering calls, oral complaints, which never should happen anyway, but if they haven't been addressing it otherwise at this 7-day notice and the intention to withhold rent is supposed to make them repair. If it doesn't, that's when you call code, that's when you do other things simultaneously that Andrea explained.
Mm-hmm. Mm-hmm.
Okay, get back to the other questions that are hiding somewhere. Okay. I'm going to try not to press anything wrong so I can post the YouTube link in the chat box. So the next question is, have you noticed landlords raising other issues besides non-payment to bypass the moratoriums?
Yes.
Yes.
A lot of times you're going to run up on non-renewal because your lease is just running out and they're not going to renew. And unless they required to by the subsidy, you're going to run into non-renewal. You're going to run into being violated for other reasons, looking to violate you so that they can then terminate the tenancy for other reasons. Or if you're a holdover tenant, meaning you didn't vacate at the end of your lease, and your lease is silent, as to whether you're holdover or you're month to month. And even if you over it, they just decide to just terminate you and not seek rent. So yeah, we see it a lot.
Okay, and someone was asking if you have any tools or information on what to look for in housing discrimination. I think that might be best suited to our recorded webinar about fair housing, but yes. If you have any thoughts off the top of your head.
Yeah, we have a whole presentation about it that we did last week and another presentation. So I would say look for the page and look at the YouTube videos. We have a lot of information about that as far as discrimination. But what you're going to look for is a protected class. Does the Fair Housing Act apply? And can the situation be addressed by a reasonable accommodation? And has an accommodation been made? Accommodation request been made?
And Suzanne and Andrea gave a lot of great information last week about fair housing. I just put the link to the YouTube page in the chat box. The webinar from last week is not uploaded yet because I was on vacation. So I apologize for the delay, but I should have that up there this week. So everyone can check out the YouTube page and subscribe and learn about all sorts of interesting topics, but lots of them feature Suzanne and Andrea. They are my superstars teaching everyone about fair housing and landlord tenant. So thank you all so much for doing this again. And I want to remind everyone that we will be back next week, same day, same time, next Tuesday, September 15th at 2 p.m. I'm not able to share the flyer in here, but it will be on the social media of Community Legal Services, Florida Legal Services, and Jacksonville Area Legal Aid. I also typed all the links to the resources that Suzanne mentioned about the eviction form builder, the moratoriums, checking the rules in your county. So those are all in the chat box for you to access. And let me just make sure we don't have any more questions. It does not look like it. So we finished right on time. Good job, everybody. Thank you for joining us. And thank you so much again, Andrea and Suzanne. See you
Thank
next week.
you. Bye-bye.
Everybody, thank you.